My name is Robin Dixon, and today I'm going to be discussing dissociative identity disorder, or DID, and how it operates in a forensic context using the State v. Greene as case example. What I really want to focus on is how this disorder is understood clinically versus how it's treated legally, because there is definitely some nuances between the two, and they don't always line up. According to the Diagnostic and Statistical Manual of Mental Health Disorder, or the DSM-5, dissociative identity disorder involves the presence of two or more distinct identity states, along with gaps in memories that go beyond normal forgetting. But what really matters here is that the identity itself is disrupted. You have the host, which is the actual person, and then you have the alternate personalities that the host typically isn't aware of. In most cases, this does develop in response to severe and chronic adolescent trauma, where dissociation becomes a way to compartmentalize overwhelming experiences. DID has a significant impact on an individual's functioning. People with this disorder often struggle with relationships, employment, and even daily decision-making. Their quality of life is often marked by instability and confusion. They're losing time, not remembering actions, and they're trying to make sense of experiences that don't feel like their own. Just imagine waking up on a beach and having no idea how you got there. That's actually a common experience for someone with dissociative identity disorder when one of their alternates make a decision to go to a new location and then the host wakes up during the experience. It's also important to note that DID is frequently comorbid with depression, anxiety, and PTSD, which can be a further nuance towards both clinical and forensic presentation and evaluations. This is significant in the realm of forensics because dissociative identity disorder challenges traditional legal constructs such as mens rea and actus reus. And this is because the host can suffer from dissociative amnesia, which are those significant memory gaps, and as we've already discussed, they suffer from those fragmented identity states, where the presence of distinct alters, each with potentially different memories, behaviors, and awareness, come to the fore. So this is where it gets really tricky, because the defense will often argue that it wasn't the host that committed the crime, rather it was one of the specific alters. And some of the times the host can't even remember that the crime was committed. So the system is faced with a difficult question. If different identities are controlling behavior at different times, who's actually responsible? Access to the case of Washington State versus Greene, 1998. And I chose this one because it's one of the more controversial intersections of trauma, dissociation, and criminal responsibility. So Greene was a paroled sex offender with a long history of institutionalization, specifically for the dissociative identity disorder, which he was diagnosed with 3 years prior to this attack. On this specific date, his therapist came to do a house visit. And according to the reports, Greene then restrained the therapist, tied her up, and held her captive for hours inside his apartment before sexually assaulting her. The violence was not impulsive, nor was it momentary. It involved acts of physical control, psychological domination, and repeated acts of sexual violation. And what makes this even more interesting is that the therapist tried advocating for him, and she advocated to the defense, insisting that Greene, as a unified person, would never have done this to her, and she claimed that he was not responsible for what occurred. Instead, she attributed the assault to one of his alleged alternate personalities, specifically a childlike identity referred to as Tyrone. It was she who claimed that Tyrone was the one who reportedly molested and raped her while crying out phrases such as, "Mom, please don't hurt me." The defense argued that these actions were then carried out by Tyrone. Greene further claimed that he had no memory of the offense at all, suggestion that the host personality was not aware, nor was he in control. The therapist stayed in support of this, claiming that he had more than 40 different alternate states. Legally, the case became less about what Greene did and more about who or what committed the crime. And this was pretty challenging when examining evidence for admissibility. So before the trial, the prosecution argued that DID was too controversial among psychiatric experts to be admitted as valid scientific evidence, and the presiding judge concurred. In the judge's word, he stated that Greene's case, and by extension of most other DID cases, experts could not help the jury decide how the disorder affected its sufferers. Moreover, experts could not say whether it made the defendants legally insane, unable to tell right from wrong, or whether it made them incapable of forming criminal intent. Experts could not even say which personality to hold accountable. Therefore, all expert testimony regarding dissociative identity disorder was barred from trial, including that of Greene's expert. Greene didn't bode very well. He wasn't allowed to have any expert witnesses testify to his mental state, and he was convicted and tried and sentenced to life in prison. It wasn't necessarily the sexual assault that landed him life in prison, but rather Washington was a 3-strike state. 3 strikes and you're spending the rest of your days incarcerated. So the appeal wasn't really an issue about the brutality of the crime, but rather whether the court erred in preventing the jury from hearing evidence that could have fundamentally altered the understanding of Greene's mental state, and therefore his sentence. So in August 1998, the Court of Appeals overturned the conviction and ordered a new trial, recognizing that the exclusion of this disorder potentially infringed upon Greene's right to a fair defense. The court noted that dissociative identity disorder has long been included in the DSM, so that it met the standards for scientific evidence. And the appeals court further stated that if Tyrone had acted without Greene's knowledge, that it would in fact be a valid insanity defense. So Greene's therapist got ready to testify. But the state Supreme Court had a different idea. And in September, they said no new trial would be needed. So it was there that the Washington Supreme Court upheld the exclusion, emphasizing that the scientific community could not reliably determine how DID affects criminal intent, responsibility, or the ability to distinguish right from wrong. The Supreme Court justified its decision by asserting that DID did not meet the requisite standards for scientific reliability or practical utility to the jury, thus affirming the state court's previous decision stating that in Greene's case, as in most DID-related cases, the experts could not offer definitive guidance on whether the disorder rendered the defendant legally insane, incapable of forming criminal intent, or even which personality should be upheld. So ultimately, Greene's case and sentence was upheld, and he spent life in prison until he passed away. So the final question is, do I agree with the outcome of this case? And the answer is both yes and no. So some of the considerations and legal challenges that were considered is that cases like Greene's force a legal system to confront a difficult reality. How do we assign responsibility when the mind itself may be fragmented? On the one hand, The severity and duration of the offense cannot be overlooked. The harm is real, and the justice system has an obligation to respond in a way that reflects that harm. At the same time, the defense raised a critical issue, which was whether dissociation and identity fragmentation can impair awareness and control to a degree that challenges traditional notions of intent and responsibility. So to truly understand that, I did some digging into some past cases that has formed the precedents for this trial. And precedents show that courts have struggled to find consistency in these situations. In U.S. versus Denny Schaefer, the court acknowledged DID as a legitimate psychological condition, yet still emphasized the difficulty of assigning legal responsibility to separate identity states. Similarly, in the case of Billy Milligan, the court accepted the dissociative framework and found him not guilty by reason of insanity, resulting in psychiatric commitment rather than incarceration. Greene, however, represents the opposite approach, where the diagnosis was excluded entirely, leaving no room for the jury to consider how dissociation may have impacted the mental state. So just comparing these three show that the legal system oscillates between full acceptance and complete rejection, with little middle ground. So it becomes hard to create true precedents or to expect to find continuity between districts. So now I'll truly explain why I both agree and disagree with the outcome. So I do agree holding Greene accountable. The behavior itself matters. This was a prolonged, control, and repeated act. It required restraint, planning, and sustained engagement, all things the legal system uses to infer intent. And at the end of the day, the law recognizes one person, not multiple identities. But I don't fully agree with excluding DID altogether, and I do firmly believe that an expert should have been able to speak at trial. So even if it doesn't eliminate the responsibility, it still provides important context about awareness and control. Ignoring it completely further created this gap because we're treating the behavior as fully intentional without considering how severe psychological disturbances may have influenced it. So a purely punitive response, which is what he got, life imprisonment, doesn't address those severe disturbances at all, nor does it take them into consideration. So for me, the more appropriate approach would be something in between. Long-term secure psychiatric institutionalization. That still holds the individual accountable, but also acknowledges that the behavior may not have come from a fully intact or unified mental state. So when we're thinking about dissociative identity disorder in the legal system, the issue isn't whether the disorder exists, because it does. The real issue is whether the legal system is equipped to interpret it. Thank you.